3, 2, 1.
We're ready to hear argument in 21-238, Pediatrics School Care against Thompson from Ellis County and the 14th Court of Appeals District.
May it please the court, Ms. Faust will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal.
Thank you. May it please the court, counsel. I'd like to address two of the issues we've raised in our briefing in this case. The first being the Court of Appeals interpretation that this court's decision in Bustamante versus Ponte to reject application of the but-for causation requirement where multiple tortfeasors are alleged to have caused an injury. The second I'd like to cover, if we have time, is the computation of prejudgment interest, which is an interesting issue. When non-economic damages, both past and future, have been awarded by the jury, they exceed the cap, and then the non-economic damages cap found in 74-301 is applied to limit those damages. Turning to the first issue, Bustamante did not change the law of proximate cause in all cases. This court applied the substantial factor test of cause effect there by itself because the facts in that case fit it within a limited category of cases in which two causes concur to bring about an event, and either cause operating alone would be enough to bring about the event absent the other cause. In looking at Bustamante, the facts are very important. There we had a severely premature infant with a 100% chance of retinopathy of prematurity developing. And there was a narrow window of time for treating that condition to avoid blindness or retinal detachment. The evidence was that both the pediatric ophthalmologist and the neonatologist physicians had the same duty to review and screen the baby during the same time period and intervals during the first 4 weeks of the baby's life, to determine when the baby was appropriate for treatment to avoid blindness or retinal detachment. And the evidence was the negligent conduct of these two physicians occurred contemporaneously during that interval, that same 4-week period. Both of the doctors allowed no screening to occur. Now, that's very different from the evidence that we have in this particular case. In that case, the court said because those doctors owed the same duty, they breached it contemporaneously during the same time frame, and the experts linked that conduct to the result. The plaintiffs did not have to present more. They did not have to present evidence of but-for causation. In this case, though, we have no evidence that Dr. Salguero and Robinson or the staff were acting contemporaneously, that Avery's suicide was certain to occur. Dr. Salguero's duties to monitor and oversee Robinson's diagnosis and treatment plan are not the same duties that Robinson owed in actually providing care and treatment to diagnose Avery with depression and prescribe Celexa. And all the experts agreed that Celexa did not proximately cause the suicide here.
You said certain to occur. Why did the plaintiffs have to prove that the suicide was certain to occur?
What they had to prove, Your Honor, was that the treatment, what Dr. Moss had said, the exploration by asking questions to provide pathways for potential other treatment would have made the suicide unlikely. And the court has stated that in the Rodriguez Escobar versus Goss case and the Dell case. In those two cases,
we said you have to show more likely than not that the result would have been different, right? Not certainly it would have.
That's, well, the certainly aspect of it comes in from Bustamante. In that particular case, it was 100% chance. It was certain that the injury would occur. And that was not the case here because the evidence was that suicide is unpredictable. It was a shock. It was the family had no idea. The friends had no idea. It was unanticipated. So that's the difference there. So when we say it was not certain to occur, that's what I mean in contrasting this case with Bustamante, Your Honor. So these cases are very different. Bustamante should not apply here. And in applying the cases that have come out where this court has addressed proximate cause in a suicide situation, again, Rodriguez Escobar and the Dow cases, this case is a lot like the Dow case if you get into the facts. There we had a history of a patient with suicidal threats. He presents to the ER, no comprehensive risk assessment. He's released. 33 hours later, he commits suicide. The court event.
So he was no longer under the care of the physician at that time, right?
Correct.
So isn't this case different in that way?
The respondents certainly have suggested that, but what this court said,
don't the facts also, aren't there also facts that the jury could have credited to that effect?
That they were
that the decedent was still
ongoing.
under the care of your client at the time she committed suicide.
Well, yes, she was still under the care of our clients at the time that she committed suicide. But in the Dow case, what's important is this court decided that issue on remoteness, that it was too attenuated.
Right, and it seems more remote in that case if the decedent is no longer under the care of the physician at the time of the suicide.
Well, if you compare the situation there, where there was no evidence that Dow could have been hospitalized involuntarily, or that he would have consented to that hospitalization, or that it would have made a difference in the suicide occurring, we have that.
That he was given information about that possibility, that was a possible treatment.
The hospitalization.
Yes.
Yes. Yes.
Okay. And so this case is different in that way as well, because the decedent and her family were not given information about those options.
The opinion of Dr. Moss is they were not asked questions that could have potentially led to other pathways. And the other pathways here, there's no evidence that Avery would have even consented. The other pathways included, for example.
How could you have such evidence if she wasn't given the information? How could you develop evidence about whether she would have consented had she known information that she didn't know?
Avery's mother testified, Your Honor, that she would not consent to counseling. She also testified that Avery had a teacher. This was another pathway that Dr. Moss suggested could have potentially been explored. And that this.
But aren't those things totally speculative whenever it just didn't happen?
That is correct, Your Honor. They are. Dr. Moss, a lot of what he says is very speculative. These pathways that could have been explored, for example, this cluster of acts or omissions of all the treatment options, if those would have been explored, then Avery would be alive today. But he doesn't explain how any of the treatment options could change the outcome.
Could she not have been continued to be prescribed the medication that had a black box warning about a suicide risk?
I'm sorry, Your Honor, I didn't get the first part of that.
Would one of the options have been not to continue to prescribe the medication for her that had a black box warning about a suicide risk?
No, sir. Dr. Moss's opinions were asking questions that created pathways toward treatment options. Psychotherapy, a network of community support, group therapy, sports, peer groups, a relationship with a teacher, a confidential advocate, and then to ask Avery separate from her mother if she was directly contemplating suicide. That's what Dr. Moss testified to.
I thought some of the testimony was that it was a breach of the standard of care to continue to prescribe the medication without proper follow-up.
Dr. Lesson, the standard of care pediatric expert, did testify that, but there is no link that Celexa, everyone agreed that Celexa did not proximately cause the suicide, Your Honor. And we have cited to that evidence in several places in our brief. In fact, when it got down to it, Dr. Moss said, if these pathways had been pursued, quote, several cumulative factors would have showed up, maybe, just maybe, more likely than not, preventing her suicide. And that can't
Say that in a different way elsewhere in his testimony without the
sorry?
maybe. Elsewhere in his testimony, did he say it was to a reasonably likelihood without using the word maybe?
He did, Your Honor. Yes.
Okay. So what do we do with that?
Well, Your Honor, I don't think that if you look at everything he says, these combined acts or omissions, he can't explain why any of these would make a difference or a change in the outcome. And he can't, suicide's not always preventable, he says. He doesn't know, he can't point to any direct factor or pathway that would have made a difference. I mean,
Could it be based on his experience in handling a lot of these cases himself?
He did rely on his experience. He admitted he had no literature. His opinions are not based in science.
Well, why is experience? We've said that experience is okay for an expert to rely on. So why couldn't he base that testimony on his experience?
Experience can be enough if there is no analytical gap. Here we have Avery has committed suicide. So we cannot talk to Avery, but we have supposition here as to what could have happened if some questions had been asked of Avery. It's speculation. It's unreliable testimony, as we have also pointed out to the court. And in that context, experience alone is just not enough. And in fact, this expert has lost patients, even with these pathways being pursued, Your Honor. So it's not. It is, and according to the arguments on admissibility, it's a soft science. But still, we have requirements under the law for proximate cause. In this case, we believe substantial factor and but-for cause had to be shown with the varying acts of Dr. Salguero and Ms. Robinson. If I could move just quickly to the computation of prejudgment interest in this particular case, without getting into the math, we had the jury award past and future non-economic damages that exceeded the $250,000 cap found in 74.301 of Chapter 74. That section requires that limit of liability to $250,000 for all those past and future damages. It limits all of them. So by limiting all of them, we also know that Chapter 74 has no component addressing the computation of prejudgment interest. So the Texas Finance Code then must govern prejudgment interest computation, and it does not allow the computation or accrual of prejudgment interest on past damages. I'm sorry, future damages. So it's incumbent then, when you're limiting all the damages that included future damages, some component of that cap must have been comprised of future damages. We believe that the better way to have computed is to assess prejudgment interest on the $250,000 equal to the percentage that past non-economic damages awarded comprises the total. Here it makes about a $50,000 difference. And we provided all those computations to the court and to the trial court and the Court of Appeals. That is the only way to effectuate the intent, we believe, of the legislature, that prejudgment interest cannot be assessed on future damages. We would ask the court to reverse the Court of Appeals decision to render judgment in favor of petitioners. Alternatively, we've raised a couple of new trial points, but in any event, we believe that the judgment should be modified with respect to the computation of prejudgment interest in this case.
Any other questions? Thank you, Ms. Faust. We'll hear the respondent.
May it please the court, Mr. Aldis will present argument for the respondents.
May it please the court and counsel. I'd like to start off with the actual testimony from Dr. Moss that I think about sums up this case. My testimony is about that we didn't get any of the information necessary upon getting a chief complaint of depression for 5 months. And we have a dead 14-year-old here, and we have a dead 14-year-old because nothing was done except throwing a pill at her and saying goodbye. Now, the ultimate question that you have to answer is whether or not the admissible evidence is such that reasonable minds could differ on the issue of causation. I'd like to point out that first that Dr. Salguero and his clinic tacitly admitted that they were negligent in the cause of Avery's suicide when they altered the records after they learned of her suicide. At the trial, Dr. Salguero also admitted that his clinic fell below the standard of care in several ways, and that they did not monitor the patient as they should have. Dr. Salguero's expert, Dr. Correa, admitted that this clinic fell below the standard of care. He also admitted that failure to treat moderate to severe depression in adolescents is likely to lead to potentially a suicide, but that it can be prevented with proper treatment. 10 people on a conservative Ellis County jury agreed that reasonable minds could differ and decided to rule in favor of the respondents. And Judge Carroll, who is a conscientious judge on the trial bench, believed that reasonable minds could differ by denying the motion for directed verdict and denying the motion for new trial. And the 14th Court of Appeals, in a unanimous opinion, believed that reasonable minds could differ on the causation evidence here. With that in mind, I would like to address the substantial factor versus but for. To me, this is really not an issue in this case, and this is why. The trial court defined the causation just like the pattern jury charge does, 50.1, and it's at 2 CR 846. And the Court of Appeals also used the same definition. A defendant's action is a cause, in fact, of damages if it was a substantial factor in causing the injury and without which injury would not have occurred.
Excuse me, may I ask, let's say if we do disagree with the opposing party about substantial factor and whether that should be considered, how were these acts not too attenuated from the suicide to even be a substantial factor?
Well, if you think about it this way, if you're under the care, as Avery was, of this clinic for these 5 months, or at least the 5 months after she admitted that she was depressed up until the time that she committed suicide, that's a continuing course of care. It's not an attenuated thing where there is a one-time visit to the hospital, like in Providence, or a failure to commit a patient on a one-time basis. That's just not the case here. Every time that Avery either received treatment or that her mother called in for prescription refills was another opportunity that the petitioners failed to elicit the appropriate information and to properly assess her depression and then do something about it. So it's different in terms of attenuation. And just to back that up, on July 31st, 2012, Avery's mother called in and said that they were out of the Celexa, and a medical assistant who has no right or ability and it's below the standard of care, issued a 3-month prescription without saying that she had to come back in. And she knew that was wrong because after she learned that Avery had committed suicide, she went back in and changed the record to say that she told the mother to come back in 7 days. Now, that 7 days would have been in the period of time between July 31st, 2012 and August 14th, 2012, when Avery committed suicide. So this is not attenuated or removed from the actions of the defendants because it is a cumulative effect when you fail to diagnose originally and treat properly. Every time there's an interaction, that same failure comes forward.
The defendant says everybody agrees that Celexa didn't cause the suicide. You agree?
I
with
agree
that?
with
Yeah.
that. I agree with that. Except to say this, and I think that this was Justice Busby's point, is that when you do prescribe Celexa, there are certain follow-up requirements that the standard of care calls for. And those follow-up requirements are that you do in 7 days when the initial prescription, you bring the patient back in. In fact, Dr. Moss testified by the time that Avery went to the clinic on April 17th, 2012, she should have been seen 6 times as a result of the prescription of the Celexa. So in that context, the Celexa matters, but the Celexa was not the cause of her death. This court has.
Well, I'm a little confused by that, because
Okay.
if it wasn't the cause or a cause, then what was?
Well, according to the testimony, the cause of Avery's suicide was the failure to properly assess her depression and then to employ all the treatment options that are available, not just a pill.
So that
That's
would
what
meaning discontinuing the drug or lessening the amount of the drug that was to be taken.
No, Your Honor. I don't believe that that's anywhere in the record. In other words, I don't believe it's
Determining
anywhere.
that the drug by itself was not enough.
I don't believe that's correct. I think that's a better way of putting it, Justice Busby. I think that I'm ready to tell you exactly where it is in the record that Dr. Moss said is simply not enough to prescribe Celexa and then forget about it. That what you need to do is all these, and he did explain the treatment options that would have been available had a proper assessment been done. But so turning to the whole issue of whether or not but for or substantial factor is the appropriate test, in Bostic, the asbestos case, this court said that those two things are overlapping concepts, and in most cases, substantial and but for are going to end up with the same result. And so there is no real distinction between the two tests, except for the proof. So in Bostic, they basically.
Mr. Aldis, don't we just have to go with what the jury charge says on that?
Well, that argument that is that the jury charge explains or is what the court should have reviewed was never raised. But I agree with you that the jury was charged in the substantial factor and not just simply but for, but it's still the same test. Because in every case where this court has said what the test has always been that is whether or not the defendant's negligence was a substantial factor in causing the ultimate harm, and for which it would not have happened but for the negligence. So it's a combination, but I think you look at the terms at the proof. For instance, in Bostic, they said it would be unreasonable to expect a plaintiff to prove that the actual asbestos fiber from the defendant's product is the one that lodged in the lung that eventually led to mesothelioma. And that sort of thought was then put forward again in Bustamante, where whether or not one defendant's negligence was a substantial factor in the harm then constitutes no evidence that the harm was when there were multiple actors. And this court just said it's long been the law in this state that a defendant's act or omission need not be the sole cause of an injury as long as it's a substantial factor. And of course, in that case, you had two physicians who together both negligently failed to diagnose and treat the retinopathy thing that I don't really recall how to say it. But in any event, it was the appropriate way to look at it was the substantial factor. In other words, you didn't have to prove that one doctor's acts were the proximate cause as opposed to the other doctor. The same thing in Windrum. This court looked at the failure to diagnose and treat a patient who had hydrocephalus, and the negligence was the failure to put in a shunt. And this court said at the same time, cause is in fact is established when the act or omission was a substantial factor in bringing about the injuries, and without it, the harm would not have occurred.
It seems though, counsel, that it's difficult to compare this to those more conventional medical malpractice cases where there's a physically demonstrable link between the misapplied shunt and the later injury, and you can just there's a physical manifestation of the botched surgery or it just sort of obviously causes the injury in a way that's just it's different here. You understanding, certainly as we do your causation arguments, there's so many intervening factors in a suicide that might or might not have made a difference, that I wonder whether it's helpful to talk about more conventional medical malpractice cases, or should we focus on the particularities of this kind of a case?
I agree with you that any case involving psychiatry, the failure to treat from a psychological standpoint, and a subsequent suicide is different than what I would refer to as a traditional malpractice case. For instance, the failure to diagnose a lump in the breast and remove it because you have pictures of it. You have, potentially biopsies and those sorts of things. So, but at the same time, I don't think this court, and I agree with you that this court should really focus on this case and what is required for causation in this case. Because unless you want to say that malpractice in the psychiatric area simply is not a cause of action because you can't prove what the mind would have done, you just have to look at the evidence in the particular case. So I will say that this case is what I would refer to as a traditional failure to assess, diagnose, and treat depression. Now, what does that mean? It means that, stepping back, we know that properly treating a patient who has a depression will more likely than not lessen the chance of suicide, starting at that point. So in the context of this case, Dr. Moss testified, and I would say that my opposing counsel continues to refer to one line when she says, maybe, just maybe, something would have been different. But that's just one line in a testimony where at least 5 or 6 times Dr. Moss said that in my reasonable probability that the failure to act on behalf, properly act on behalf of the petitioners was the proximate cause or a proximate cause of Avery's suicide. So what did we have? So it starts with the failure to properly assess her depression. What then Dr. Moss did is he explained what actions could be taken upon a proper assessment. And those actions were psychotherapy. Those actions were set up a support network, nutritional counseling, group therapy, role model relationships, confidential advocate, emergency telephone contacts, and to directly ask the patient if she had suicidal ideation. In this case, there was evidence that was disputed evidence, but the jury was entitled to believe that Avery and her mother were not told, or Avery was not asked if she had suicidal thoughts or if she'd ever had suicidal thoughts. And that's one of the starting places that we have to go to. So after you go to the omissions, he says, so it's mostly in the form of omissions that I'm speaking towards. And had any or most of these things been done, it is my, professional opinion within a reasonable medical degree of certainty that Avery would be alive with us today. What the petitioner,
Mr. Aldis, how do we weigh your opposing counsel's point that there was evidence on each one of those that that wouldn't have made a difference. Basically, had Avery or her mother known of those avenues, they wouldn't have chosen to pursue them.
Well, I disagree with her characterization of the evidence, and this is what I'm going to say, is that although Avery's mother testified that Avery did not want to go to counseling, what Dr. Moss says is that if you have the doctor suggesting that that is an appropriate treatment, then maybe Avery doesn't say to her mother that, I don't really want to go. And I think basically what the petitioners are arguing is that for all those avenues of treatment that Dr. Moss explained, that you have to follow each one of the rabbit trails and say that each rabbit trail in and of itself was a proximate cause of of Avery's suicide. And I don't believe that's the case. The causation testimony is the failure to assess and properly treat her Avery's depression over the 5 months that after she admitted that she was depressed, that if you would have followed the appropriate standard of care, then it's more likely than not that Avery would have not committed suicide. You don't have to put on evidence that each individual act that you suggest should have been taken would have led to would have been a cause in and of itself.
Well, let's say that we agree with that. You do have to connect the dots, and you
Correct.
have to be able to get from here to here to here to here to here. So how does the record do that?
Okay, well, if you review it, there is evidence that the only thing that was discussed in the original March 2012 visit was that Avery's mother thought she was depressed, and that's it. There was evidence that the actual encounter lasted less than 15 minutes. Dr. Lesson said that in order to do an appropriate assessment, it would take more. In fact, it might take an hour. It might take multiple visits. So you have the violation of the standard of care is that there was not an appropriate assessment. There wasn't an explanation that the medication that she provided could create suicidal ideation, that the mother in this case should have paid attention or should watch her closely. And I believe the testimony was from Avery's mother is that if she would have told me that this had a black box warning and that I needed to watch Avery, I would have been on her like a hawk. She would have brought her in for the visits had they told her to, but there was no, the evidence is that there was no statement to come back in and be evaluated. And so when you look at all those,
there are two cases from this court that declined to find liability in suicide cases. And I understand you argue they're distinguishable. Are there court of appeals cases that uphold liability, medical liability for suicides?
Yes, Your Honor, there are. But if you ask me to quote what they are, I'm not going to be able to do it.
I didn't see them. They may be in the briefing and I missed them. I didn't see them.
Well, I think the argument with respect to the two cases that the petitioners have talked about and that this court ruled on are just so factually dissimilar that they're not helpful to this court in determining whether or not causation was proved in this case. I think, because they were just one-time visits, because they related to the laws of involuntary commitment versus voluntary treatment, those two things just don't really equate with this case because she was voluntarily treating. She was going to the doctor's office. She was seeking help for her depression. And it's just that the petitioners in this case negligently failed to properly assess and treat her depression. And as a result, the expert said, it is my opinion, based upon reasonable medical probability, that that was a cause of Avery's suicide. And that's what we're left with. And to suggest that you have to go down every rabbit trail and then show that each one was a proximate cause is simply not correct. Thank you for your time. If there's any questions, let me know.
Any other questions?
I just want to comment that if you would like to submit some type of a post-argument brief on those Court of Appeals cases that have held in your favor, then you're welcome to do that.
Thank you, Your Honor.
Thank you, Mr. Aldis. We'll hear from we'll hear rebuttal.
Thank you, Your Honors. Just a couple of things I'd like to respond to. First of all, the Rodriguez-Escobar case is not a one-time visit. There's a physician-patient relationship. There is a prior commitment. In that particular case, though, the physician determined that the situation at the time did not require hospitalization, and the patient then was not hospitalized and committed suicide. So in that case, this court did consider a situation where there was prior treatment by the physician. And again, the patient comes in for additional care. I want to talk a little bit also about the remoteness component in looking at whether or not you have to have a tie-in for every one of Dr. Moss's potential pathways that he talks about. This pathways toward treatment options that could have made a difference in the outcome. He can't even, he could not state that any of those pathways would have made any difference at all. Not all of them. He couldn't state if any would. And that is the state of the record. If you look at remoteness in this case, what did we know? That Avery's mom is telling Dr. Salguero's office every time they're getting the refill that Avery is doing much better on Celexa. She's happy. The night before, she's happy. She seems normal. She's helping giving her brother a bath. She's playing games with the family. The suicide is a shock. It's unexpected. And Avery's mom says, even the friends told Avery's mom. This came out of the blue, out of nowhere. This is what is being reported to the staff and to petitioners. There's no evidence that she's not doing better, that her condition declined, that it worsened during this 5-month period after she started Alexa. Again, her mom did say she did not want to go to counseling. She did have this teacher that she could confide in, which did address a couple of those pathways. So we think this case is, when you consider substantial factor alone, it's too attenuated for proximate cause to establish or to affirm the liability here. Now, with respect to the court's charge, you know, when we presented this case to the Court of Appeals, we said the evidence is legally insufficient to support the jury's answers to question number 1, subparts 1 and 2. And the court's charge included proximate cause definitions from the PJC that included substantial factor and cause in fact. And it wasn't until we got the Court of Appeals opinion that said, Bustamante says we only have to look at substantial factor, is when we knew the court didn't look at but-for cause. And there hasn't been a showing of but-for cause here, and this is not the type of situation, as I explained, and we think we've explained in the briefing, that provides it. So there's not been a waiver of that point. That is the standard of review. The Court of Appeals must look at the evidence in determining whether it's sufficient based on the court's charge. We raised that here in our petition and in our briefing, so we don't believe there's been any waiver. The Court of Appeals should have required both. With that, if the court
So
has,
if we agree with you on that, Ms. Faust, then we don't have to consider what the proper standard would be, because we just go with what's in the charge, right? Whether but-for is required or not doesn't really matter if there was no charge objection.
that is correct, Your Honor, under Osterberg and cases following that. That would determine what the court must do and look at the evidence in that light. And then even if the court affirms the Court of Appeals on substantial factor and the evidence here and disagrees on attenuation, of the time and the circumstances here, then the court should still look at the accrual of prejudgment interest, because the judgment would need to be modified, we believe, in that respect. So with that, I appreciate the court's time, counsel, and wish everyone stay safe. Thank you.
Thank you, Ms. Faust. Any other questions? The case is submitted and the court will take another brief recess.